Friends, criminal defense attorney Ryan Pasiga. Today I'm going to tell you what a preliminary hearing is in a criminal case. So the news is breaking, of course, that the alleged shooter in the Charlie Kirk murder matter is going to appear in court today and will decide whether or not he wants a preliminary hearing. Some states allow for a preliminary hearing in criminal cases and some don't. In the states that do allow for a preliminary hearing, the lawyer and client have a decision whether to do a preliminary hearing or not. A preliminary hearing is a hearing where if you decide to take one, the prosecutors would have to put on a witness or multiple witnesses on the witness stand under oath, and that witness would kind of summarize the evidence and talk about the what's called probable cause that the defendant allegedly committed the crime. And the advantage to doing a preliminary hearing is a couple things. One, you get to hear a summary of the prosecution's evidence from usually a case agent. So it might not be every police officer or detective that participated in the case or any what are called lay witnesses, which mean people that don't work for the government. But they will have to summarize the allegations and the evidence against the defendant. And then, of course, the defense gets an opportunity to cross-examine that witness in court under oath and explore the strength or weakness of the case against the defendant, and also get some testimony locked in that could be used for future use, so that if that person testifies differently later in a suppression hearing or in a trial, we can impeach that testimony with the prior testimony from the preliminary hearing. So you get to use it to get some additional discovery in the case, and then, of course, for potential impeachment evidence later. And of course, at the end of the hearing, a preliminary hearing, the judge has to decide whether the government, meaning the prosecution, has met its burden of proof that there is a probable cause to go forward with the charges against the defendant or not. Some lawyers decide to waive a preliminary hearing. Generally speaking, I don't like to waive preliminary hearings. It's a free opportunity to get some testimony early on in the case and also take a shot at whether there's probable cause or not. So they're valuable in my opinion, but each lawyer and client have to make that decision on their own. That's what a preliminary hearing is. If you have questions about criminal law in state or federal court, I'm criminal defense lawyer Ryan Pasiga, and you can find me at arrestedmn.com. Let me know if this helps today.